Good afternoon, everyone. A very warm welcome to you who have joined today to learn about what you do when you receive an unfair dismissal. In today's webinar, we'll be going through managing an unfair dismissal claim step by step. We'll examine how to respond to unfair dismissal claims, including grounds for challenging the appropriateness of the claim, preparing for conciliation conference, what to expect during conciliation settling claims, and what happens when Fair Work Commission decides whether a claim is fair or not. Whether you've been through the unfair dismissal mill before or not, there will be something useful for you all. Our webinar today will be presented by Brett Barton. My name is Francis. I'll be your facilitator for today's webinar. Brett joined NatRoad in December 2017. Brett is one of the member services officers at NatRoad and has extensive workplace relations and human resources expertise gained from working in a wide range of industries throughout Australia. We'll be aiming for about 40 minutes with presentation time, and we'll be recording the webinar today. So you don't have to take notes, however, feel free to if you'd like to. The recording and the slides will be made available to you once the webinar has concluded. If you do experience any issues, please send them through so I can assist you. I'd like to draw your attention to the control panel today, where you'll see a questions box. If you do have any questions for Brett or myself, don't be shy. Please type them, feel free to type them into the box at any time, and we can also then address these at the end of the presentation. Brilliant. Thank you very much for everyone's patience. I just had a few slight technical issues there. As I said, my name is Francis. I'll be your webinar moderator today. Certainly, if you have any questions, I would like to direct your attention to the control panel today, where you'll notice there is a question box. If you have any questions for Brett or myself, please don't be shy and type them into the questions box at any time, and we'll be able to answer these at the end of the presentation. Now, without further ado, I'd like to warmly welcome Brett Button to begin the presentation today.
Thanks, Francis, and good afternoon, NatRoaders, and welcome to today's webinar. So you've received an unfair dismissal claim. And as Francis was saying, we're happy to answer questions at the end of the webinar. But if something pops into mind in the meantime, feel free to put fingers to keyboard and put that question straight through to us. The program for this afternoon is basically on the agenda slide before you. It'll cover off the message that we're trying to get across today, what's all the fuss about, what's so important about unfair dismissal claims, the process that's used for unfair dismissal claims in a roadmap, who can and can't make an unfair dismissal claim, how you go about responding to a claim, that question, can't we just sort this out, that pops up in every unfair dismissal claim, and we'll look at the conciliation phase in that part of the program. And also, if a settlement or resolution isn't possible on an agreed basis with an unfair dismissal claim, we'll look at what happens then when it goes off to the Fair Work Commission for arbitration. And of course, what goes into being prepared for dealing with a claim when one comes along. So, moving right along, the message that we have basically is that it is just business. An unfair dismissal claim is just part of having a business, really. I've been involved in, I don't know how many unfair dismissal claims over the years, and certainly the emotions can run pretty high at times, particularly in small businesses where the owner of the business might be involved in the termination of an employee, and there's an unfair dismissal claim that flows from that. Sometimes the relationship has broken down to such an extent that people get very emotionally involved in trying to defend an unfair dismissal claim, and that can colour their judgment. So one of the key things that people would be advised to remember is that this is just part of being in business, is that you're probably going to deal with one of these things eventually, and to treat it like you would any other business challenge, coolly and calmly. The second thing to remember is know what to expect. So don't walk into the management of an unfair dismissal claim blindly. I know some people turn up to conciliations or even arbitration hearings and without any idea of what's going to happen. That'll make for a pretty unpleasant experience. You need to be prepared. You need to know what's going to happen. And moving into that third one, be prepared, is when you are involved in a conciliation conference or an arbitration hearing, make sure you've got all of your ducks in a row before you go into that proceeding, because it's too late once you're there to try and make stuff up as you go along. You need to be well and truly prepared to argue your case, have your witnesses ready, make sure you've complied with all of the directions, all of that sort of thing before you get there. Otherwise, it will end in tears. So, what is all the fuss about? Unfair dismissal claims that we're talking about today are made under this beast, which is the Fair Work Act 2009. As you can see, it grows over the years. It's one of those bits of legislation that doesn't actually get any smaller. It's a bit of federal law. Before this particular act, there was similar unfair dismissal legislation going back for quite a few years. So we're also talking about dismissals. What is dismissed? As far as the legislation is concerned, there's a technical definition that's terminated at the initiative of the employer or forced to resign by the actions of the employer. So they're the two criteria basically for being dismissed. And it's a dismissal that is called harsh or unjust or unreasonable. So that when we say unfair dismissal, what we mean is one that is harsh or unjust or unreasonable. And we'll look at what that means a little later on this afternoon. Also, A dismissal that is unfair is one that isn't consistent with what's called the Small Business Fair Dismissal Code. If you're a small business where you employ less than 15 people, there's a slightly special set of rules for you. There's a publication put out called the Fair Dismissal Code for Small Business. And basically, if you comply with that, you're going to be considered to have terminated somebody fairly, not unfairly. And also, if somebody is made redundant, but it's not a genuine redundancy, then it'll be an unfair dismissal as well. So they're the things that we're talking about this afternoon, and included in the what's all the fuss about part of the show, we have some statistics. So in the financial year 2016 to 2017, the Fair Work Commission received over 14,000 unfair dismissal claims, which, yeah, that's not insignificant. Of those, 8,880 were resolved at conciliation. So you can see there that most of the claims, the vast majority, once they get to a conciliation, they will get resolved one way or the other. The stats show that 81% of those conciliation claims that were resolved involved some form of payment to the applicant, the person that made the unfair dismissal claim, but there was no reinstatement or re-employment that resulted from those proceedings. So again, the vast majority of these claims, they do get settled, and they get settled by way of a payment. And 84% of those settlements involved a payment of less than $10,000. So, yeah, $10,000, it's a reasonable amount of money for most people. But some people don't get a payment at all. Others get more than that as part of the agreed outcome. Of the claims that actually go through to the Fair Work Commission for arbitration, for a decision being made as to whether the claim is unfair or not, of those, 127 were decided as being fair and 160 as unfair. And of those unfair ones, under 45%, or 45% of those resulted in a compensation payment of less than $8,000. So there's just some basic facts from the Fair Work Commission's annual report that basically give you a picture of the state of play for unfair dismissals in Australia. They produce a whole bunch of other different stats as well. And it's a sad and sorry story, but you can see that the majority of these claims will get settled, and there is a perception that is out there that basically an unfair dismissal claim is the opportunity for a former employee to basically shake the tree and see how much more money falls out. There is definitely a sense that people do pay for their problems to go away with this process. Anyway, moving right along. If you employ people, basically an unfair dismissal claim is going to be a business risk. It's not just the cost of a settlement that you have to take into account. There's the time and effort that's involved in managing these claims and responding to them, turning up to conciliation conferences and hearings as well. So that needs to be taken into consideration when you're making decisions about how you're going to cope with claims being made against you. You also can't stop an unfair dismissal claim from happening. Employees or former employees can make an unfair dismissal claim regardless of whether they have been sacked unfairly or not, or whether you think they've been sacked unfairly or not. You can't stop them from making a claim, even if they have no legitimate basis. They're still able to fill out the form, pay the application fee, and get the process rolling. And then it's a case of you trying to combat that. So you can only manage and defend the claims as best you can, and hopefully this afternoon we can help with preparation for that process as well. So claims also can't be ignored. You know, some people like to put their head in the sand and hope that the problem goes away when they see one of these claims, and it doesn't happen that way. The Fair Work Commission will continue to actually process an unfair dismissal claim and determine it in the absence of any input from the employer. So it won't go away, it'll only get worse, and decisions can be made against you without your involvement in the Fair Work Commission process. So that sort of sets the scene. If we move to the process itself, there's hopefully not a too complicated slide in front of you there, the roadmap. We'll look at the lower part here first, because this is the way that most unfair dismissal claims are processed. So if we start with the red arrow, basically it comes down to an ex-employee usually decides that they want to pursue an unfair dismissal claim. They fill out a form that's available on the Fair Work Commission's website. They lodge that form with the Fair Work Commission. They pay an application fee, which is currently $70.60. They can ask for that fee to be waived if they are experiencing financial hardship. That claim has to be made within 21 days of the termination of their employment taking effect. Now, there is the ability for the Fair Work Commission to extend that period of time if there are extenuating circumstances, exceptional circumstances as to why an extension of time should be granted. But in the absence of that extension of time, basically the Fair Work Commission should disallow any late application. But you might have to go to a hearing to actually figure out whether an extension of time should be granted or not, and indeed argue against an extension of time being granted. So yeah, the claim goes in, it goes to the Fair Work Commission. The Fair Work Commission puts it into their system. It sends a copy to you, the employer, along with a notice of listing saying when a conciliation conference has been lodged. Along with the application, they'll give you an employer response form, which you need to fill out within 7 days and send back to the Fair Work Commission. We'll talk about that form in greater detail later on, so I won't dwell on it at the moment. If you don't have any jurisdictional objections, and they do happen from time to time, we'll talk about those in a little while. The claim then will go off to what's called a conciliation conference. That conciliation conference is conducted by a Fair Work conciliator. They're not a commissioner, they're basically an employee as opposed to somebody appointed under a commission. The conciliation conferences these days are run usually by telephone, so it's a teleconference. The face-to-face type conferences that used to occur in the good old days, they were a bit more fun, probably a better process, but they're not done these days by and large, mainly because of logistics and costs. So the conciliation conference is conducted by a conciliator. The conciliator's main aim is to try and get a settlement through this process. So you'll spend maybe an hour or 90 minutes on the phone going through the application that's been made. Basically, you need to be in a position to explain your side of the story, what happened and why. Keep in mind that an outcome can't be imposed on you through this conciliation process. However, it's still important to explain why you've terminated the employee, why you've dismissed them, and how it isn't an unfair dismissal. And the reason for that is it comes down to the conciliation process tends to turn into a negotiation for how we're going to settle this. And the conciliator will certainly push that. They'll try and poke holes in your position and what you've done, likewise with the applicant, to point out how difficult life is going to be if you don't settle now. So it can get a bit of a pressured situation, especially if you're not aware that this is the way that they can operate. So with the conciliation process, it is, as I say, it's an opportunity to tell your story. The applicant will be given an opportunity to tell their story as well. So generally, they'll be asked to explain why it is they think they've been terminated unfairly and what they want out of the proceeding. You'll be given the opportunity to say why you think the application didn't result in an unfair dismissal, and respond to the applicant's claim for usually money or their job back or whatever it is that they're asking for. So you'll get the opportunity to do that, and usually the conciliator will talk to both parties separately as well to try and broker a deal. If, as I say, it's a good opportunity to actually explain your side in some detail. Don't go on at great length, don't drag things out, but make sure you get your side of the story across. Basically, what you're trying to do is show that you're in a strong bargaining position, that you know what you're doing, that you didn't do the wrong thing, and that if it isn't settled down, it goes to arbitration, you won't be a pushover at arbitration either. So it's important to actually think of this as a negotiation and how you're going to position yourself in the negotiation. If you get to a settlement, the settlement is recorded in writing in what's usually called a deed of release or terms of settlement. It's a document that you can produce yourself or the applicant can produce, but often people use the conciliator to produce the written record of the agreement of the settlement. They have a standard document. There are generally no issues with it, but before you sign anything, make sure it actually says what you think it should say, that it includes the amounts that are going to be paid if there is any payment, that the standard clauses that are usually in there, things like a no disparagement clause, so you don't say nasty things about each other, and a confidentiality clause that both you and the applicant don't comment on the settlement, other than maybe that there was one, but you don't disclose the terms of the settlement to anybody else, unless you're required to by law, or you need to get financial advice or legal advice. So before you sign anything, make sure the document says exactly what you believe it should be saying. So that is normal process through to conciliation. If you've settled, you'll get that written agreement. If there is no settlement, then the process carries on. The applicant is in the position of being able to say, yes, they want the Fair Work Commission to decide this case, in which case it'll go to either a formal conference or a formal hearing, and both of those are conducted by a commissioner. So they're much more formal environments than the conciliation conference. In the case of a formal hearing, they're usually public, so you might find that there are people in the gallery when you're in the hearing. The hearing in particular, but for both of these type of proceedings, it is much more legalistic. The Commission will expect you to have submitted written submissions as to your side of the case. It will have expected you to put together witness statements from anybody who's going to be called as a witness. Witnesses who provide statements will need to turn up and participate in the proceeding, and under oath or affirmation give their evidence, and their evidence will be cross-examined by the opposition as well, and they may be interrogated by the Commissioner. So it's a very court-like, very formal, very legalistic type of process, and if you haven't been through it, it can be quite daunting, particularly as examiner. Is basically to pick holes in your evidence to show that you don't know what you're doing, or you don't know what you were doing at the time, or that perhaps you're being a bit loose with the truths. So it can be a little difficult. When it comes to the arbitration, basically the Commission will decide whether the termination was harsh or unjust or unreasonable. If the dismissal was fair, then the case will be dismissed. If the outcome was that the dismissal was unfair, then the Fair Work Commission can do a number of things in terms of trying to remedy that unfair dismissal. It comes down to an order for reinstatement, which basically means giving the person their job back and making up any lost pay that they would have suffered in the meantime. There is re-employment, which is basically giving the person their job back from a prospective date, and it doesn't include any involvement of payment for lost income. There is also compensation that's available too, so that if the person isn't given their job back, they're able to be awarded compensation. And the compensation, there's a formula within the law as to how that is calculated, and it comes down to taking into consideration things like the effect of the order for compensation on the employer's business, how long the employee had worked for the employer, how much money the applicant would have earned if they hadn't been terminated between the time of their termination and the time that the order is made, how much they've earned from other sources, so did they have another job in the meantime, and how much did they get back from that. It also includes consideration of, has the applicant tried to mitigate their loss? Basically, have they tried to reduce the impact of their termination, which normally means them having gone off and found another job. So if they've gone off and put out a dozen different job applications and secured another job, then they would have been deemed to have mitigated their loss. If they sit at home going, woe is me, and don't go out and do a bit of job hunting, then they won't have basically tried to have mitigated their loss. And all of that would count against them in that latter case when it comes to awarding compensation. There's also consideration of how much the employee's misconduct contributed to their dismissal. So it's possible that the employee is considered to have, by whatever they did, that there was some level of desert when it came to being terminated, but the employer might have got the process wrong, therefore compensation is awarded. Now, that formula is applied by the Commissioner, and there is also a cap in terms of how much can be awarded by way of compensation, and that's 26 weeks remuneration, or half of what's called the high income threshold. And currently that half level of the high income threshold is $71,000. So there is a limit as to what the Commission can do by way of financial compensation. So the Fair Work Commission's decisions, again, some people might like to try and ignore any outcome, and certainly some employers have, but Fair Work Commission decisions can be enforced through the courts. So you can get court orders actually ordering you to comply with the Fair Work Commission's decisions, and penalties for non-compliance as well. So it can turn quite serious if people don't actually do what they're meant to do and comply with the orders of the Fair Work Commission. So if that's the normal sort of process along the bottom there. Along the top, we have the process that really deals with jurisdictional objections. So as I say, there are some grounds for an employer to object to the Fair Work Commission dealing with an unfair dismissal claim, and we'll look at those in some detail later, but for the purpose of the slide, there are a couple of different avenues there. If the employer notifies that they have jurisdictional objections, in some cases those jurisdictional objections will be determined before the Commission looks at whether it's an unfair dismissal or not. And in other cases, it will actually decide the jurisdictional objection at the same time as deciding whether there was an unfair dismissal or not. So it'll look at the jurisdictional issue first, and if it grants that that jurisdictional objection, basically it'll just dismiss the case. If it doesn't grant that jurisdictional objection, it'll then move on in the same process to decide whether there was an unfair termination or not. So it'll get it all over and done with in one hearing as opposed to possibly two. So again, it's when you're going back to filling out the employer response form, it's pretty important to put some thought into whether there are any jurisdictional objections and whether you think you can mount those objections and how you want to do that too. Throughout this process, you can be represented if you so choose. You don't have to be if you don't want to be. In the conciliation conference run by the conciliator, there's generally no issue with being represented at all. However, once you get into proceedings that are conducted by a commissioner, there is a bit of an issue in that if you are represented by a lawyer who doesn't actually work for you as an employee, or a consultant, or some other organisation, then that representative will need to seek leave of the Fair Work Commission to appear. And it's not just a please can I appear in this matter type process. They actually have to just address some statutory criteria as to why their presence, their involvement in the proceeding would actually be of some use, some benefit to the conduct of the proceedings. Now, if you use an employee of an employer association that you belong to, like NatRoad, that issue of seeking leave to represent you doesn't occur. Employer associations have a legal right under the Fair Work Act to actually represent their members without any need to seek leave to appear. So as I say, whether you're represented or not, it's entirely your choice. Some people are pretty comfy going through this sort of process themselves, especially if they've done it before. For others, it's not so much the case, and getting a representative would be a good idea. Especially, I guess there's some value in having a representative too, that if you do find it difficult to divorce yourself from the emotions of the case, and that can be a challenge too. It's often good to have a more dispassionate set of eyes involved in the process. So, you know, there's this question then of who's in and who's out. Who can and who can't make an unfair dismissal claim. It just isn't open to everybody. For an unfair dismissal claim, if we look at the left-hand side of the slide, basically those people can apply. You have to be a national system employee, and that's pretty much people in the vast majority of the workforce in Australia. A national system employee, it doesn't include state government employees in New South Wales, Queensland, Western Australia, South Australia and Tasmania. It doesn't include local government employees in New South Wales, Queensland and South Australia. In Western Australia, it doesn't include employees of employers that are what are called non-constitutional corporations. So that would be things like individuals, sole traders, partnerships and trusts. So it doesn't include employees of those sort of businesses in Western Australia, but it does in everywhere else in the country. And it also doesn't include employees of the public sector in Victoria at some higher levels as well. But that's generally the listed exclusions. So you can see there that pretty much most people in the Australian workforce would be included as a national system employee. You also need to be a person protected. That's a nice flash phrase from the Fair Work Act. That basically means that you've completed what's called a minimum employment period. And for a small business, that's 12 months, and for others, that's 6 months. So the minimum employment period, it's a bit of a misnomer. It doesn't mean that the person has to be employed for that period, but if they terminated within that period, then they're not eligible to run an unfair dismissal claim. Likewise, a person protected is also somebody who is covered by an award or an enterprise agreement, and that they're paid, somebody who's paid less than the high income threshold. And the high income threshold at the moment is $142,000 a year, but it goes up on the 1st of July every year, so it'll go up by some statutory formula in the next few weeks. So that's, and the other thing, of course, is that you actually have to be dismissed. And you'd think that's a fairly simple question, but sometimes that can be quite a difficult thing to figure out when people say things in the heat of the moment, like you can take your job and do something with it. Yeah, there actually needs to be an active dismissal that's occurred. On the excluded side of things, we look at people who weren't dismissed. So again, that comes into that consideration of what are generally thought of as resignations or non-resignations in the heat of the moment. Perhaps the person wasn't your employee. Sadly, often it happens where labour hire employees who have been working for an employer for a while get a little confused over who their legal employer is, and when they're let go, they run an unfair dismissal claim against their host employer, not their actual legal employer, which poses some difficulties for them. So, you know, if you're not actually an employee, you can't run an unfair dismissal claim. If you're out of time, that's a 21-day time limit we talked about earlier. If you're dismissed within the minimum employment period, if your dismissal is consistent with the Small Business Fair Dismissal Code, you also can't run an unfair dismissal claim as well. And if it's a case of a genuine redundancy, then you're excluded from running an unfair dismissal claim too. If we look at some of these in a bit more detail, a dismissal has to be a dismissal at the initiative of the employer. So the employer has to do something to actually bring the termination of employment about. Also, it could be a resignation due to the conduct of an employer forcing the employee to resign. So that's what's been called over the years a constructive dismissal. Basically means you've pushed an employee to the point where they think that they can't continue to work for you, so they quit. And you know, examples of that might be giving them unpleasant jobs to do, only unpleasant jobs, limiting their access to overtime where everybody else has access to overtime, isolating them in the workforce, not giving them the same training, to outright bullying and harassment and things like that as well. So those sort of things generally come into play when we're looking at the conduct of an employer in forcing somebody to resign. There are also a bunch of people that are deemed not to have been dismissed when they've been employed under a contract for a specified period or a specified task or for a specified season, and their termination happens at the end of that task or period or season. So those sort of people are also excluded from being able to run an unfair dismissal claim too. But if you actually terminate them before the end of that task or season or that period, then they would be eligible to run a claim. So, and of course, when it comes to the minimum employment period, a small business is somebody who employs less than 15 employees at the time of the dismissal, and that's just a simple head count, so you don't have to worry about full-time equivalent employees or anything like that. And if you have a casual employee, then casual service for the purpose of calculating the minimum employment period, that only counts if the service was regular and systematic, and the casual employee had a reasonable expectation of ongoing regular and systematic employment if they hadn't been dismissed. If you are in a situation where your business has been acquired by another business, or you have acquired another business, then there's some nuances when it comes to looking at the service of employees of businesses that you've acquired. So if you have that sort of situation where you've had employees transfer in, then you need to look at those in particular when it comes to unfair dismissals. And we spoke a bit about the small business code previously, so I'll go back to that. But just quickly on the genuine redundancy side of things, there is a test in the Fair Work Act that deals with what is a genuine redundancy, and it's pretty much a tick list. And it comes down to redundancy is where you don't require a person's job to be done by anybody due to operational requirements or changing operational requirements, sorry. You have complied with any consultation requirements under any award or enterprise agreement, and it's pretty important that you do that if you have those consultation requirements. And it wouldn't have been reasonable to redeploy the person to another part of your business or a related business. So it's not just your direct company. If you have other companies that are related to the business where the employee was employed, you should have also looked at redeployment opportunities in those related businesses as well. So before any redundancies are gone through, it's really, really important to actually go through and make sure you can tick that list, that it is a genuine business change, that you have complied with those consultation obligations, and that you've looked at redeployment opportunities as well. So moving to how do you respond to an unfair dismissal claim. Basically, once you get the notice from the Fair Work Commission that a claim has been made against you, you have 7 days to fill out your employer response and send that back to the Fair Work Commission and provide a copy to the applicant as well. So we're in with that 7-day time limit. Unlike a lot of other time limits within the legislation, that 7 days isn't sort of a hard and fast, you get punished or beaten up if you don't comply with it. That's not the case. If you are going to miss the deadline, it's a good idea to let the Fair Work Commission know that that's the case and that they can expect the form in the near future. Eventually, the Fair Work Commission will try chasing you if you haven't responded anyway, to see what's happened. So when you're filling out the form, make sure that you are definitely the responsible employer, that the person was your employee. As I say, sometimes people can get a bit confused about who employs them if they're a labour hire person. If they've resigned, make sure that you indicate that on the form as well. Make sure before you fill out the form that you actually know what happened. If you're not the person that was directly involved in the unfair dismissal, in the dismissal process, make sure you get the information from those people that were, so you can fill out the form accurately. If you have any jurisdictional objections, put those onto the employer response. If you don't, you can actually indicate an objection later on using a separate form, but it's always good if you're going to have an objection, indicate one up front. And the sort of objections that come that are available: the application was out of time, the applicant was employed for less than their minimum employment period, the applicant wasn't a national system employee, you're not the employer, that's always a good one. The applicant was not your employee, also a good one. The applicant was employed for a specified task, period or season and dismissed at the end of that time or event. The applicant has made multiple applications about their dismissal, so there's an inability for an applicant to actually run an unfair dismissal claim and a general protections claim and other claims as well. So there's a limitation. People can't just forum shop, basically. If the applicant was a short-term irregular casual, then again, that's grounds for a jurisdictional objection. If the applicant was a ward and enterprise agreement free and earned more than the high income threshold, as I say, that's currently $142,000, then you can have run an objection on that basis as well. And that $142,000, that high income threshold, doesn't just include salary or wages. It also includes some non-cash benefits too, not super guarantee contributions, but if you have extra super, then that would go towards their remuneration. If they have personal use of a vehicle or a phone or accommodation, then you can include that into the income threshold as well. If the applicant was genuinely made redundant, you can use that as a jurisdictional objection. If you've a small business and the person was terminated in accordance with the Small Business Fair Dismissal Code, again, objection. If the applicant was demoted but without any significant reduction in pay or duties, that's also grounds for a jurisdictional objection. And of course, if the applicant genuinely resigned voluntarily, again, you can notify a jurisdictional objection. That's getting into a tongue twister at the moment, for that reason as well. So once you've notified, once you've indicated on the form that you have an objection, the Commission can do a couple of things. One, it might hold a telephone conference beforehand to try and figure out whether there's some substance to the objection or not, and whether the employee actually, or the applicant, agrees with the objection, and the case should then disappear. So they might do that, or they might list a hearing, basically to try and sort out whether the objection should be granted or not. And as I say, some types of objection will be heard in a separate hearing, and if they're successful, that's fine, then the claim goes away. If the objection is unsuccessful, then it will go through to a separate hearing to determine the merits of the unfair dismissal claim. Other jurisdictional hearings, objections, sorry, they get determined in the one hearing. They decide the jurisdictional issue and the merit issue in the one process. So, but importantly, when you're filling out your employer response, think about these things before you fill out the form, sign it and send it back. If you make a mistake or you have an omission, feel free to send in an amendment when it comes to the employer response. So, just revisiting the conciliation conference, the question is posed here, can't we just sort this out? This is a prime opportunity to try and resolve an unfair dismissal claim. You will probably feel some pressure going through a conciliation conference to settle, but keep in mind this is your decision. You don't have to if you don't want to. And you can settle at any time, not just a conciliation conference. This is a negotiation, it's a market situation, it's what you're prepared to give to make the problem go away, it's what they're prepared to accept. So keep that in mind, because it's not so much about the rights and wrongs of the termination. This really is a negotiation. But having said that, I still think it's pretty important to explain your view of what happened and why, basically as a way of optimising your bargaining position. So if conciliation doesn't work, sometimes employees, they drop their claim, they lose interest, it's all a bit too difficult. They thought they were going to walk away with a bag of cash. It doesn't happen, so they just go on and get on with their life. So sometimes they abandon the proceedings. If that doesn't happen, then they have the option of going to, as I say, an arbitration, where the Fair Work Commission, the Commissioner, will decide whether the person was terminated unfairly or not. Once this happens, you've lost your only opportunity to be sure of the outcome. The only way to know what the outcome is going to be is to settle. Once you've got a commissioner involved, they're going to make a decision, and they may make a decision, based on different criteria from what you think they should. It's going to be a fairly legalistic process. You need to be able to not only explain what you did, but to provide evidence and proof of what you did and why you did it. So if you thought an employee did something wrong, you need to be able to demonstrate that you have proof that they did it wrong. You have to be able to show that you complied with the legal tests of a harsh, just, reasonable termination. And your evidence will be tested. And you know, your view of what common sense is or how these matters should be treated, your sense of right and wrong is pretty irrelevant when it comes to the formal process. It's a legal process that the Commission has a whole bank of precedents that it uses to guide itself through these proceedings, and then individual commissioners can have a slightly quirky way of approaching unfair dismissals and other matters for that matter as well. And keep in mind too that whilst there are different options available to the Commission when it's trying to remedy an unfair dismissal, the primary remedy is reinstatement, you know, putting the employee back in the job that they had, and usually for the employer that's the worst possible outcome. So that's an unpleasant thought to keep in mind. Now, if we look at what the Fair Work Commission is going to do, it'll decide whether a termination is harsh or unjust or unreasonable. It'll decide whether and use that criteria for assessing whether it's an unfair dismissal or not. So again, the Fair Work Act spells out a checklist of things that need to be taken into account by the Commission in deciding whether the termination is harsh or unjust or unreasonable. The list is there on the screen for you. There has to be a valid reason to do with the capacity or conduct of the employee, so that's their performance and their behaviour. If the applicant was told of the reason, so you know, there's an expectation that basically before you terminate somebody, you explain to the employee what you think they've done wrong. They need to have been given an opportunity to respond to the reasons if it's related to their capacity or conduct. If they've asked for a support person to be present during any process leading up to a termination of employment, if you've unreasonably refused the presence of that support person, that would be taken into account as well. The impact of the size of the employer's business and the impact of that size on the process followed is taken into account, along with any absence of dedicated human resource staff, you know, and the absence, what impact that has on the process. That'll be taken into account as well. And there's the fudge factor right at the end, anything else that the Fair Work Commission considers relevant. So they can take into account a variety of different things. Often the employee's conduct with the employee's conduct will fall into that last consideration as well. But all of these things, when you read an unfair dismissal decision, you will often see the Commissioner has gone through each and every one of these considerations and addressed them in their decision. So it's important when you're actually presenting your arguments either at a conciliation or in an arbitration, that you actually address this list as well to make sure you cover off all of these grounds. So when it comes to being prepared, being a Boy Scout is probably a good thing for all of us. So we do need to be prepared when entering into these sort of environments. You'll see there that it's titled the 6 Ps, and the observant will notice that the very first dot point only has 5, but I'll leave you to figure out what the missing one is. But very early in my career, it was hammered home to me that poor preparation prevents proper presentation. So the better prepared you are for conciliation conferences, for arbitration proceedings, the better the result is likely to be. However, preparation for addressing an unfair dismissal claim starts long before you ever dismiss anybody. It comes down to how you manage your staff, how you treat your people, how you run your workplace. So if you have flaws in the way people have been treated, they're going to show up in unfair dismissal proceedings, and it's a bit late then to try and fix them or explain them away. So, the best preparation for managing and defending an unfair dismissal claim is to make sure you've got decent policies, decent procedures, that you always treat your employees fairly, that when it comes to performance and behaviour management, that people are given the opportunity to answer any allegations against them, to provide a response, that unless it's a serious misconduct issue, that people are given the opportunity to actually improve, and that their performance and behaviour is monitored, that you go through the whole procedural performance management thing. And if you've tuned into David's webinar a few weeks ago, he would have addressed all of those issues in terms of fair performance management processes. So, you know, the true preparation starts every day, long before you've actually terminated somebody. However, if you go to actually addressing a claim that's been made, the easiest, simplest way of approaching this is to, one, build a timeline of what happened and when, who was involved, where events occurred, why, make sure you've identified witnesses, get statements from those witnesses, and get any supporting documentation, and get all of this together and put it into one package that you can use for basically constructing your arguments as to why you've terminated somebody, why it's not an unfair dismissal, why there shouldn't be any compensation or any reinstatement or re-employment audit, all of that sort of thing. So compare your story with the legal requirements, that list of what's harsh or unjust or unreasonable. Go through that list and make sure you can tick off each of those things and match your story against those requirements. Also, if you're going to run a jurisdictional objection too, you will need to look at the facts of your particular case and how they match with the requirements for a jurisdictional objection. And tell your story clearly. It can be sometimes very difficult to actually recount coolly and calmly what happened, and without getting a bit hot under the collar or without getting distracted by irrelevancies. So yeah, it often helps if you're doing this yourself. You might want to test your argument on a professional colleague or a friend to make sure that your message is actually coming across clearly, where we often hear what we want to hear when we're doing stuff ourselves. So that's, I guess, all I have to say about being prepared, and just end up with the reminder. It is just business, so try as far as possible to keep the emotional side out of your decision making when it comes to unfair dismissals. That can be a real challenge at times. Don't go into these things blind. Know what you're getting into in terms of what happens at a conciliation conference, what happens when you need to fill out the employer response, what happens if you're running a jurisdictional objection, what happens if you're going off to arbitration. And where do you find out about this stuff? Well, one, you can get advice from ourselves, of course, but the Fair Work Commission also produces a whole bunch of information for unfair dismissal participants, including some videos about what happens at different types of proceedings. So they actually produce a fair amount of information, ideally targeted at people that aren't represented. So there's that information available too, and of course, be prepared. You can't be over-prepared for any form of proceeding in the Fair Work Commission, whether it's a conciliation conference or a formal hearing that's arbitrating an unfair dismissal claim. So that's all I have to say for the moment. You'll be pleased to know, and I'll be happy to answer any questions should anybody so choose.
Fantastic. Thanks, Brett. So we have come to the end of the webinar now. So we'll move on to questions as Brett indicated. Remember, if you have any questions, please feel free to type them into the control panel on your screen, and we'll be more than happy to answer any of those at will. I believe we've got a couple questions here, Brett, at the moment. Can an applicant claim unpaid entitlements at the same time as an unfair dismissal?
That's a good question. It's something that often comes up when you're dealing with unfair dismissal claims. It's people complain that they haven't been given their payment in lieu of notice, or they haven't been paid some of their wages, or they haven't been paid their leave when they were terminated. The Fair Work Commission, in dealing with an unfair dismissal claim, will not take into account generally whether you've been paid correctly per your contract of employment or an award or enterprise agreement or the national employment standards. However, you can lodge separate proceedings for alleging underpayment of wages for an award or an enterprise agreement or you could make a complaint to the Fair Work Ombudsman, and they may choose to pursue that complaint separately. But generally, those sort of underpayment issues are taken, require separate proceedings to address, and wouldn't usually be picked up in a consideration of whether it's unfair or not. Having said that, if compensation was ordered and there was missing wages, the Commission may include that in its deliberation about the compensation that was due.
Brilliant, thank you. I think we've got one more here. Can I sack one of my for someone for not wearing the safety gear that I provide them? For example, the driver refuses to wear the company issued safety boots.
Right.
Where do I stand?
Maybe not in the safety boots. Yeah, this is again a good question, and it does happen from time to time, as I'm sure some of you have experienced. Safety boots mightn't always be the height of fashion or the most comfortable things that people are required to wear, and some people don't like wearing them. The answer is a maybe. I wouldn't jump to the conclusion that you'd be dismissing somebody because they're refusing to wear their safety boots. I think you'd start off with why don't you want to wear them? Look at whether there are any medical issues involved, and if there are, then one, the person mightn't be fit to do their job because they're required to wear safety boots to actually do their job. So you might be considering what to do with somebody who can't do their job until their feet are fit to wear safety boots. If there is no medical reason or no other valid reason why they're not wanting to wear safety boots, then it comes down to is it a case of a lawful and reasonable instruction to require them to wear the safety boots? If it is, because it's a genuine requirement of the job, then you're in a situation of either being able to go through a disciplinary process and making the person aware that if they continue to refuse to wear the boots, you're considering them to have refused to obey a lawful and reasonable instruction, and that their employment is at risk. And ultimately, if you go through that sort of disciplinary process, ultimately you could be in a position where if the person remains recalcitrant, then they could be terminated. But the facts of each matter would rest alone. You can't sort of generalise that it's okay to or not okay to. You really have to look at the individual facts.
Fantastic. There's a couple of questions here. My contract has finished and I have organised full employment for all of my staff with the new contractor. Have I fulfilled my obligations and will not have to worry about redundancies?
Right. It would come down to questions of one, are you a small business or not? Because the redundancy requirements for a small business are a lot less than for a non-small business. In that situation, you would need to go through and make sure that the new employer, they accepted the prior service from the period that the people were employed with you. You should go through a process of basically, technically according to the awards, go through a process of seeking the Fair Work Commission to grant an exemption from making redundancy payments on the basis that you've actually found work for your employees, and that the service that the employees had is going to be taken on board by the new employer, including any current leave liabilities. So I'm not sure what sort of funding arrangements were involved in the transfer of business there. And you'd have to be able to demonstrate that you were basically integral to all of your employees getting continuing work with the new employer too. So again, there's a chance that the short answer is yes, but you'd need to go through and look at the individual circumstances.
Brilliant, thanks, Brett. We've got another question here. What about if we have a policy of no smoking in the company vehicles, and an employee continues to do so after several warnings, both written and verbal, where do I stand in ability to dismiss an employee for this reason?
Yep, it's no different from any situation. Non-smoking in a company vehicle is pretty standard sort of workplace policy these days for a whole range of reasons. Presumably the employee was made aware of the policy early on, and if they weren't, they are now, because you've said that they've been warned. If you've gone through the proper disciplinary process, that they've been warned that their behaviour is unacceptable and why, given the opportunity to respond, it'd be pretty hard to understand how they could have a valid reason, but they still need to be given an opportunity to have their say as to why they continue to smoke. So any reasons that they come up with, you need to address as well. But if you've gone through the process and given them sufficient warnings, the opportunity to rectify their behaviour, and you've got to the point where they've been given a final warning and advised that if they offend yet again, their employment would be terminated, you'd be in a fairly sound position, I would have thought. But again, it comes down to the process, making sure you get the process right. It's not just the validity of the outcome, it's the process that the Commission would look at as well.
Brilliant. We've got another question here, Brett. I've found someone who I think will do a better job than my current employee. Can I terminate them?
Yes, we'd all be in trouble. The short answer is pardon me, you would need to have a valid reason for the termination of an employee, and finding somebody that is able to do that employee's job better generally wouldn't be considered a valid reason. So the valid reasons need to be about the person's capacity or conduct. So if they have issues in terms of what they're doing, they're not performing to your standards, they're not behaving to your standards, then you can address those separately, and that might ultimately result in their termination. But you wouldn't just terminate somebody to make way for somebody who can do their job better, without having gone through the process of managing the performance first, and ultimately that resulting in the person's termination.
Brilliant.
Yep.
Fantastic. I think we've got just one more question, if there isn't from anyone else. My employee doesn't fit into our organisation's culture. Can I terminate them lawfully? What can I do?
Yeah, this is a good one. People talk about cultural fit quite often, and it's one of those vague things that's a bit like attitude as well. What we need to look at is, what is the person actually doing, their behaviour? So what is it that isn't fitting with the organisation, the way you do business? So is it are they grumpy with people? Are they recalcitrant? Do they refuse to do what they're told? Those sort of things. So you need to look at what they're actually doing and how that isn't in accordance with your company's standards. Then look at, have those standards been conveyed to the individual? And if they have, then you can start on a performance management process. If they haven't, then you need to go through that line in the sand process of saying, well, this is the way we do things here, and making sure that the employee is aware of your standards, and then if they don't comply, go through the performance management process. But it can be difficult. It's not a quick fix, and it can be quite a test to actually pin down what it is that is making you think that the person doesn't fit in. But you really need to focus on the behaviours of the individual and how that doesn't comply with your performance standards or your conduct standards.
Fantastic, thanks, Brett. It looks like that's all the questions that we have time for today. Thank you for everyone who took the time to submit their questions, and also to view today's webinar. And also thank you again to Brett for hosting it.
My pleasure, Francis. And just one last word for those who had questions and want to discuss those further. I'm happy to field those questions over the phone. And likewise, anybody who didn't get a chance to ask questions, feel free to phone up and we can talk through what troubles you.
Brilliant, thank you. Now, everyone, there will be just a short survey once we've stopped the webinar, which would really appreciate your feedback. And as Brett said, if there's any further questions, please get in touch with us. And thanks again. Have a lovely afternoon.
Thank you.